Ladies and gentlemen, welcome back to another episode of Money in Medicine. In today's episode, we will be focusing on the practicalities of a will. And in studio today, we have a very special guest, Frans Hattingh, CEO and founder of MRD Wealth Solutions. Frans is actually the reason why Stefan and I joined the financial services industry a couple of years ago and why we are doing this podcast today. He was the inspiration. He was the reason why we started in this industry, and we are very privileged to have him in here today. Frans, welcome.
Thank you very much, Werner and Stefan. Looking at you two now, I can't imagine that I've done this 5, 6, 7 years ago. So it's been a long time coming, and it's really an honor for me to be here with you today.
Thank you. Frans, for all the listeners, would you just give them a little bit of background of how you started in the industry? You've been in the industry for approximately about 25 years. So you've got a wealth of experience that you can share with us. So just a little bit of background, how you got into the industry.
Werner, yeah, sure. I don't think anybody comes in this industry automatically and just decide, I want to be a financial advisor. There's probably a few people that set out their careers being a financial advisor. I wasn't one of those. I was in a normal corporate environment when I was recruited, motivated, inspired by friends of mine to join the industry, pretty much like you and Stefan. And that happened about, not 25 years, it's going on 25 years, but 22, 23 years ago. I started off in the industry in the Free State, in Bloemfontein, in a normal corporate environment, and I started with Liberty Life as a broker consultant. I did that for a few years, and then, like this industry, opens up a lot of opportunities for you. So I relocated from Bloemfontein came to Johannesburg, where I've been for the last 20, 21 years in the Johannesburg area. I spent about 10 years with Liberty. And after 10 years, I moved to another company. I joined PPS, where I spent about another 9 years with PPS, also in a sales capacity, in a leadership role. And I left PPS at the end of 2016. And when I left PPS, I decided I don't think I've done enough in terms of giving back to this industry, because the industry in itself has been very, very good to me. It gave me a lifestyle that I could never imagine I would have had. And the most important thing is it gave me the opportunity to help people. And when I started the company, I called it MRD Wealth Solutions. A lot of people may think, what does MRD stand for? But it's a very simple concept. It stands for making the right decisions. And that's what we do daily.
And I think it's for that very reason why we wanted to invite you onto this platform and to have the discussion, because what people will be focusing on today is the practicalities of a will, not the legalities, but why it's important to have a will. You just mentioned now that you joined the industry to help people. And a will is one of the most important things you have to get in place, especially when you've got a family. But not only when you've got a family, because a lot of people have the misconception that if you are single, if you are new in the working environment, you don't need a will. But that's actually completely wrong. So why would you say it's important to have a will?
Werner, I think that's one of the aspects that a lot of people know they need. They think I will attend to it at some stage, but I don't think anybody or everybody necessarily understands the importance of a will. If we just look at our own country in South Africa, and the same goes for everywhere in the world. I read stats the other day that about 70% of people living in the United States do not have a will. In South Africa, I think it may be more or less the same. It can be even higher. 75 to 80% of people, of South African citizens, do not have a will. Oh. And of those people who have a will, do not know whether it's a valid will or not. I read another article not too long ago where the Master of the High Court that about 50% of wills of estates that are registered with the Master are insolvent estates. So I think the importance of a will is something that's completely overlooked. And it's something that people must be more aware about. If you die without a will, not that anybody wants to think and talk about dying, but if you do not have a will in place, it can have a devastating effect on your family, on your relatives, and it's just it can turn into an absolute mess.
Yeah. Frans, I think just to lay also a bit of a foundation, I know the terminology is thrown around between the difference between a will and a living will. Just in a very high layman terms, what is the difference between a will and a living will?
Stefan, I think a living will is something that a lot of people do not actually want to talk about. And the main difference is a will is what happens to my property, to everything that I own the day I die. In a living will's instance is what are my wishes and my wants that happens to me while I'm still alive. So if I can make it practical, when people go into an induced coma, for instance, or they have been in a severe accident and they are connected to life support systems, a lot of people don't want to go through that. And a living will determines what happens to you while you're still alive, how long you can be on life support. And it can have, obviously, massive financial consequences for a family because medical technology and advancement in South Africa and worldwide is at the point now where you can literally be kept alive for an indefinite period of time. And the financial consequences of that can be massive for a family if you are on a life support system, in a ICU, in a hospital, and people just don't have the means and the money for that because it can, if you ultimately pass away, you may sit with a situation where there's no assets, no money available for the family that remains behind.
Thanks. So I know one of the big benefits of will, obviously, is that you can determine how the assets will be distributed. What is the case if there's no will? How will those assets then be distributed?
That's a good question. When it will still be distributed. I mean, there's no way that it's just going to hang in the air.
Yes.
But the laws of interstate succession will immediately come into play. Two problems with interstate succession is it's going to take much, much longer for that estate to be wound up. The consequences for a family that remains behind are going to be massive. And the other thing is you don't have any say in how your assets will be distributed. So if I can make it a practical example, if I want to give my house, I want more than one property. If I want to give the one property to my wife and the other one to my children, I wouldn't have that say anymore. The executor of the estate will decide where those assets will go.
Yeah, and I think a lot of the time, because there's also, I think interstate succession, there needs to be an equal distribution as well.
Yeah.
So a lot of the time, you might sit with the risk where those assets are being distributed, so it's going to be co-owned by more than one person, or alternatively, it might be sold off, and then the proceeds must be split between the heirs.
Yeah.
Which is difficult. And I think also on interstate succession is that if you don't have a will in place, like you mentioned, it takes much longer to wind up that estate. Yeah. Because one of the benefits of a will as well is you can actually appoint an executor of your choice.
Absolutely.
To administer that estate. And when you don't have a will and you don't have that nomination to appoint an executor, you're sitting with a problem where your estate has to be reported to the master of the High Court. The master of the High Court then needs to basically appoint an executor, which is usually a law firm that's on their panel. But that can take months. And then in the meantime, you are sitting with a situation where accounts isn't being paid, you are falling into arrears on a property payment, all those kind of things as well.
That's a massive problem. We're sitting with a situation just now, as we speak, where one of our clients passed away. I mean, he wasn't sick or anything; it just happened, and that's the scary part about life. We don't know when we're going to die. This person passed away with a will, but he didn't make provision in terms of his will for maintenance for as a child that's still at university.
Sure.
He was paying the rent for the property, for instance, and he was paying an allowance like pocket money to this child. Finally, a student at Stellenbosch University, and all of a sudden, dad's not there anymore. Divorced family, and we can talk about divorce as well because that makes it even more complicated. But divorced family, and at the moment, this child is sitting without any income, with no money coming to her. So she can't pay her rent, and purely because of the time that it takes. And I want to say bad financial planning, but a lack of financial planning.
Yeah.
The other thing that I want to quickly touch on before we move on is on the point of an executor. We've seen it quite often where when you have this discussion in terms of assisting a client to set up a will, there's always a big debate on who's going to be the executor because there's a fee involved. And I think a lot of people don't want to pay that fee. They would rather say, listen, I want to nominate a family member to be my executor because that fee that needs to go to the executor, I'd rather then pay that to the family member than paying it to an expert. Being in the industry for a couple of years, what is your experience on that? What would you say it's a good decision? What is your take on that?
Yes. The appointment of an executor, I see in most instances where you have husband and wife and they have a joint will, for instance, where they will say the surviving spouse will become the executor on their estate. Or we appoint a child as the executor in my estate, depending on the circumstances, obviously. My view is, I think it's a very important factor to take into consideration to appoint a more independent person as the executor of your estate. And now I'm talking from personal experience. As you know, my wife passed away about 8 years ago. And we, as a financial planner and as a CFP, a certified financial planner, I'm supposed to know better. But I was the executor. We had a will, a typical will that I'm talking about now, where the surviving spouse would be the executor of that estate. It's a traumatic experience because all of a sudden you've lost your life partner and now you have to walk around with a death certificate daily in your pocket.
Sure.
Because you have to wind up that estate. So I will guard against that, stay away from that concept, appoint somebody. You can co-execute. You can be a co-executor.
So you can still be involved.
You can be involved, but you're not going to do the daily winding up and closing of accounts. And we talk about simple things here. It's changing a television license.
Sure.
It's changing a postal address. It is closing bank accounts, closing cell phone accounts. We don't think about those kind of things, but it's a very important thing to consider. Get somebody independent. And by the way, you talk about the executor's fees. When you have a co-executor, fees is something that can be negotiated. And make sure that you know that the fees can be negotiated. You do not have to go with the stock standard 3.25 or 3.5% executor's fees of the value of the estate. It is something that can be negotiated with whoever is going to wind up your estate. And make sure that you find somebody knowledgeable. Another example is if you have the surviving spouse as the executor of your estate, 99% of the time the people have no idea what to do. No idea.
And I know on the point of the fees, I know they also include a sliding scale when they draft the will. So sometimes that sliding scale can also be maybe asked for, just to say, well, incorporate that into the will to say if you guys are the executor, then work on a sliding scale. So the more the assets, the lower the executor.
That's why I
fees
say
that they charge.
it's sometimes important to be a family member, somebody close to the family, to be a co-executor. Just on that point of maybe appointing a child as the executor, if you have an estate that is not financially solvent. And we know we're not going to talk about the legalities now, but the executor has the power to dispose of some of those assets. And if it's one of the children being the executor of an estate, you may have a brother and another sister, and there's another family, there's a mom, there's people involved in this estate, and one person's going to make the decision to start selling off property to make sure that there's enough liquidity in that estate. I've seen families really torn apart by just this very simple situation. So rather get an independent person, and you don't necessarily have to work with a bank or an attorney. You can work with financial advisors. A lot of financial advisors, your broker, your trusted financial advisor is the ideal person to be an executor of an estate, because they know the entire financial situation, and they know what the intricacies are of the estate plan, for instance. So you don't look at the will in isolation. It has to always be looked at in conjunction with your estate plan.
Frans, another benefit of having a will or drafting a will is you can express your funeral arrangements.
Yeah.
What does that entail?
That is a clause in your will where you express how you want to be, what the remains of what your remains must happen to when you die. So it's either burial, traditional burial,
Yeah.
or it may be cremation. And even that, it's a very small little thing. But I've encountered situations where there was an enormous fight amongst family members. That the one said, my mother or my father wanted to be buried, and the other children said, we don't think it's a good idea. Let's rather go for cremation. And even that, a small, simple little thing like that, can cause an enormous issue in a family. And it's a grieving family, so you want to try and avoid that. And that's why I think it's important for every individual to have.
Yeah.
And I think apart from will being important for the distribution of your assets, it also is important to manage that conflict after you're away in terms of a family, because like we've discussed now on an executor level, as well as the burial instructions, it just avoids a lot of conflict amongst family members, where one says that my mom would have been buried, or other one says that my mom would have been cremated, as an example. Yeah. So it basically makes provision that there's no family fights.
That's definitely, it's something that has to be in there. There's a number of things that has to be in a will, and we're not going to go into that detail now, but that kind of arrangement is something that's quite important as well.
Gentlemen, so I think we've had this discussion before. Just to explain why also in a will, it is practical and very, very important to nominate a guardian if there's minor children involved. So what is your views? Actually, question to both of you.
Steve, I actually want to start. We had this discussion earlier this year, because we both have minor children, and we updated our wills. And to my surprise, because I've been advising clients coming from a legal background, I've been advising clients for many years in terms of setting up a will and going through the will information sheet in terms of what information needs to be contained there. And when we get to the guardian stage, I always say to them, listen, you have to have a discussion with your wife or your husband, and then decide on a guardian for your children. And it always seemed, sitting on this side where I didn't have children, as a very easy conversation. And I would have always made a joke and said, listen, it can become a difficult conversation. So open a bottle of wine and have a discussion. Until my daughter was born and we had to update our will. And then you quickly realize that it's actually a very difficult discussion to have.
No, it's a massive issue. And I think it's something that's very often overlooked. If you don't make provision for that in your will, and you haven't had the discussion with whoever you want the guardian of your children to be, the consequences may be that somebody has to decide what's going to happen to your children. And I touched on divorce earlier. In the event of a guardian, I mean, 90% of the time, 95% of the time, you lose one family member. It's either the husband or wife that passes away, and the other parent is still there to look after the children. But if you have the death of both parents at one stage, or you have a divorce situation where there's custody of minor children, and if the person who has the custody of the children passes away, you may have an unfit parent on the other side, and you don't know what's going to happen to your kids. And now we're talking about guardianship only, but I mean, it's making provision for financial provision for the guardian for the guardian to look after your children, because there's normal expenses that has to be incurred. School fees has to be paid. So making provision for guardianship in your will is of the utmost importance. And that's why it's so important that you review your will on a regular basis, because life happens, things go wrong. The guardian may pass away or become incapacitated to look after your children. So it's not a once-off event that you have to do.
And I think it's important to have a discussion with the guardian that you have basically identified, and to make sure that they really understand the importance of that and that they are on board. Because I think a lot of time people will have the discussion and they would assume that should I pass away, my child would go to a brother, a sister, a family member.
Can they afford it?
But can they afford it? And even though, let's say you've made adequate financial provision for that family member to take in your children, the other thing is, do they have the capacity? Because it's also going to be a massive disruption to their lifestyle. So are they completely in agreement, and do they have the full understanding and commitment that would happen? because that's also very important. Because if there's no commitment like that, and there's no financial provision, you might end up with a situation where, as hard as this might sound, that your child can end up in an orphanage. Because if that child is not looked after in a proper way financially, and there's no the circumstances where that children has to stay in, that child can be taken away.
And also looking at fostering a relationship with whoever the guardian's going to be, because you sometimes find that there's an agreement between brother and sister or between family members that if something happens to both me and my wife, my kids will go to my brother living in Cape Town. But I don't see my brother in Cape Town that often. I might see him once or twice a year. My children never see my brother. And I think it goes beyond the will now, but it's how you structure and how you manage it. But making sure that there's guardianship and provision, capital and income provision in terms of your will is vitally important. And here we're talking about a testamentary trust, because a lot of people say, but I don't want my brother or my sister to inherit an X amount of money, but because what if they don't look after my child? And they use money for other stuff. Money is a terrible thing, guys. Money, sometimes it's a brilliant thing to have, but it's the root of all evil. And I've seen many occasions where there are breakups in families because of money. So in a case like that, for a guardianship, there must be a testamentary trust in your will, an income distribution that can support the family, the guardian, and your children to that extent.
Because that was actually my next question while we are talking about minors, is what is a testamentary trust? Because it's something that's quite often talked about, but practically, why would you need a testamentary trust in a will?
Testamentary trust is something that you always say, in terms of my will. It's not a trust that is like an inter vivos trust that is established while you are still alive. The testamentary trust will only be established in the event of your death. And the sole purpose of the testamentary trust is to make provision that your will, your wishes, what you want, your property and everything that you worked for in your life, that you want to bequeath to your children, goes into a testamentary trust. So they are normally for minors, not only for minors, but it's also for dependents like disabled children or people that you have to look after. It can be parents, where you don't want them to inherit a lot of money and they squander the money, or they don't know how to look after the money. And through a testamentary trust, the money will then, the interest and some of the proceeds of that investment, of that trust, will then accrue to your children over a period of time. There's also a time limit to it, and people can decide when they want the testamentary trust to be dissolved. It can be at the age of 21, 25, whatever the decision is. And then the proceeds, or the assets in that trust will then go to the children when they're grown up and being able to look after themselves.
Frans, yes, thanks so much. I think there's still a lot more that we can discuss. We can go into how digital assets needs to be distributed, as well as the safekeeping of passwords and online accounts. Those are all important things that you have to mention in a will. We can also touch on global assets, the efficiency of estate liquidity and taxes. But we would definitely like to invite you onto another episode. We are unfortunately running out of time, but thank you so much for your time. We really appreciate it. It was very insightful and valuable, and we appreciate your time.
Thank you
Definitely.
very much,
Yeah, definitely. I think from my side as well, we will definitely have to do another episode where we go in a little bit more complex, where we focus a little bit more on the complex side of a will. But from my side as well, Frans, thank you so much. We really appreciate your time today.
Yes, thank you. Thank you for your time, and thank you for inviting me. I really appreciate it.
So if it is your very first time that you are watching this channel, we do hope that you found this episode specifically very useful. Please feel free to go to the bottom of this page, share your thoughts on the comments section. We will get back to you. Also hit the like button if you find it useful, and subscribe for future content. Until next time, plan the plan.